In its demurer, Arlington County first denies that there is an actual controversy, citing for authority Charlottesville Area Fitness Club Operators Association, the Albemarle County Board of Supervisors, 285 VA 87 98 2014. Before a complaint for declaratory judgment can be entertained by the Circuit Court, it must appear that there is an actual controversy existing between the parties based upon an actual antagonistic assertion and denial of right. However, at paragraph 84 of the original complaint, under a caption heading title in bold-faced and underlined typed words, claims, and subtitle, italicized type, describing the County of Arlington, the following words, pled in beyond required particularity, appear clearly, specifying the actual controversy and framed with pinpoint statutory references regarding the alleged unlawful actions. Further, at the opening of its demurer, Arlington County acknowledged, when ruling on a demurer, a trial court accepts all facts properly pled and any reasonable inferences from those facts as true and decides whether the allegations present a valid cause of action, citing to EAMC v. County of Hanover, 291, VA 13, 2016. But simply examining what on appearance appears to be the most heinous and egregious act, denying a person emergency shelter during a hypothermia season visited upon by an unprecedented winter cyclone bomb that killed from exposure at least 21 persons of record across the country, no reasonable person nor court might agree that the potential death of one more homeless African American due to exposure to the cold because he was denied services available to any resident is not a controversy at all. Anyone who completed the first year of law school and a class in torts, the universe from which the subset of tortious interference with business expectancy is drawn, even if in the less than common context of a political or advocacy campaign, is familiar with the doctrine of res ipsa loquitur, hardly a case of first impression in the Commonwealth, and it is well explained in Danville Community Hospital v. Thompson, 186 VA 746, or 43 SE 2nd 882 1947 thusly. The doctrine of res ipsa loquitur is an evidential presumption not to be invoked to overcome evidence, but to be applied in its absence. Citation omitted. It applies where the injured person is powerless to ascertain the cause. Richmond v. Hood, Rubber Products Company, 168, VA 11. The application of the doctrine does not relieve the plaintiff of the burden of proof to establish the defendant's negligence. Virginia Electric v. Lowry. In Hines v. Beard is this statement from the oft-quoted case of Sweeney v. Irving, 228 U.S. 233. In our opinion, res ipsa loquitur means that the facts of the occurrence warrant the inference of negligence, not that they compel such an inference, that they furnish circumstantial evidence of negligence where direct evidence of it may be lacking. But it is evidence to be weighed, not necessarily to be accepted as sufficient. That they call for explanation or rebuttal, not necessarily that they require it. That they make a case to be decided by the jury, not that they forestall the verdict. Res ipsa loquitur, where it applies, does not convert the defendant's general issue into an affirmative defense. When all the evidence is in, the question for the jury is whether the preponderance is with the plaintiff. There is no good reason why the application of the rule should be limited to cases involving a particular activity. It should apply wherever the essential reason for its being exists. As said in George Fultus, Incorporated v. New York, the doctrine of res ipsa loquitur is not an arbitrary rule. It is rather a common-sense appraisal of the probative value of circumstantial evidence. It requires evidence which shows at least probability, that a particular accident could not have occurred without legal wrong by the defendant. To negative every possibility that the accident occurred in some extraordinary manner which would exculpate the defendant is often impossible. In the administration of the law, we must be satisfied with proof which leads to a conclusion with a probable certainty where absolute logical certainty is impossible. Neither should it require any explanation nor amplification that the mere fact that an accident occurred does not warrant application of the doctrine. It may be utilized only when the circumstances of the incident, without further proof, are such that in the ordinary course of events, the incident could not have happened except on the theory of negligence. Beer Distributors, Inc. v. Winfrey, 190 VA 521, 1950. In such a case, the doctrine raises a presumption or permits an inference of negligence. It is not to be applied, however, when evidence is available. Cooper v. Horn, 248, 417, 1994. Certainly, the litany of facts alleged in complaint regarding the agencies of Arlington County amount to more than the slings and arrows of outrageous fortune. William Shakespeare, The Complete Works of Shakespeare, Hamlet, 2013. Albeit dismissed, including at least 109 felonious email transactions suffered by the pro se plaintiff Webb and former Arlington Public School Board candidate, which were recently forwarded to Attorney General Mark Herring for investigation because both the Arlington County and Alexandria Police Departments chose to ignore them, raised sufficient notice to the defendant Arlington County to alert them to an action in tortious interference of a business expectancy, and their demurer should reasonably be denied. In Maryland Department of Education v. U.S. Department of Veterans Affairs, 98 F. 3rd, 165, 4th Circuit, 1996. The 4th Circuit noted regarding statutory construction, there are, however, rare and narrow exceptions under which courts may stray beyond the plain language of unambiguous statutes. One such exception arises if the literal application of statutory language would lead to an absurd result. See Crooks v. Harrelson, 282 U.S. 55, 1930. For this exception to apply, however, the absurdity must be so gross as to shock the general moral or common sense, and there must be something to make plain Congress's intent that the letter of the statute is not to prevail. Moreover, specifically in the Commonwealth, in Cleves McClellan v. Shaw, 93 VA Circuit 459, 216, expressly treated the issue sovereign domain as subject to the shock the conscience test. Arlington County further denies that the pro se plaintiff Webb has pled factual allegations to support a claim of tortious interference of a business expectancy, reciting the following rule for elements in that cause of action. Number 1, the existence of a business relationship or expectancy with a probability of future economic benefit to the plaintiff. 2, defendant's knowledge of the relationship or expectancy. 3, a reasonable expectancy that absent defendant's intentional misconduct, plaintiff would have continued or realized the expectancy. 4, damage to the plaintiff. Commercial Business Systems v. Halifax Corporation, 253 VA 292, 1997, citing Glass v. Glass, 228 VA 39, 1984. Arlington County argues the facts alleged concern plaintiff's political expectancy, not a business or economic expectancy. But perhaps in hasty research, they overlooked the various courts throughout the United States that have recognized a cause of action under tortious interference for political or advocacy campaigns, as in Banneker v. Graham, 225 S. Sup. 3rd. 1. D.C. 2016, applying the rule more akin to that articulated in Chavez v. Johnson, 230 VA 112, 335 SE 2nd 97, 1985, which asserts that a plaintiff present an argument that establishes prima facie that there was 1. The existence of a valid contractual relationship or business expectancy, eliminating the requirement for an economic benefit. Moreover, the court must consider the absurdity of the argument brought by Arlington County, which would prevent any cause, such as Emily's List, Greenpeace, Save the Whales, or Welcome the Mothership, from finding civil relief if similar actions alleged in the complaint had occurred against them, shocking the conscience. Despite the lack of success among at least 2 candidates in advancing a claim in court under the theory of tortious interference, in Hart, 382, S.W. 3rd at 918, and Wallace, 2011, W.L. at 6210633, nonprofit seeking entities, as in Others First Incorporated, the Better Business Bureau of Greater St. Louis Incorporated, 829 F. 3rd 576, 8th Circuit 2016, have actually prevailed. But as the courts do not explicitly express how they derived a decision for a valid claim in those cases, actual legal research is required, delving into the multiple citations referenced but not explained in the cases, the most common of which appears to be Glass v. Glass, cited also by Arlington County, which refers to the critical reader to the Bowl Moore Company Incorporated v. Brunswick Corporation, 297 A. 2nd 61, 1972, regarding the chief point of contention, specifically that of a business expectancy, which it derivatively describes as that of a property right, citing to United Kosher Butchers Association, the Associated Synagogues of Greater Boston, Incorporated, 349 Massachusetts, 595, 211 NE 2nd 29, Superior Judicial Court, Massachusetts, 1965, where it states, the benefits attaching to a contract or to an advantageous business relationship are recognized as property rights, and any unjustified interference with their enjoyment is actionable, not, as one may assume, an expectation of a profit or immediate economic benefit. Like the court in Wallace, 2011 WL 6210633, 2011 opined, it is hard to fathom how anyone could have a legitimate business expectancy in a political office, and asserted there that plaintiffs have not shown that Deputy Wallace had any right to expect that he would be the Republican nominee, much less the eventual winner of the general election. Arlington County erroneously or tactically frames the question for this honorable court, stating the facts alleged concern plaintiff's political expectancy, not a business or economic expectancy. But if the business expectancy of a political candidate is correctly expressed as a right in property, the proper inquiry for this honorable court is to discern the nature of that property right that would accrue to such a litigant candidate or former candidate advancing a tortious interference claim. It is well established under Virginia law the expectancy of remaining in business is too general to support a tortious interference claim. Levine v. McCleskey, 881 F. Sup. 1030, EDVA, 1995. And just as businesses fail, there is no dearth in history of candidates who, as Zig Ziglar said, squatted to rise, but got cooked in the squat. Yet, while on a case-by-case basis, especially in local politics, the string of one-time wonders is long and distinguished. For one who chooses politics as a profession, one swallow does not make a summer. Neither does one fine day. Similarly, one day or brief time of happiness does not make a person entirely happy. Aristotle, the Nicomachean Ethics. And as every first-year law student studying administrative law learns to scream due process in every case, he or she also learns that the source of those magical words for practice are found in Green v. McElroy, 360 U.S. 474, 1959, which stands for the proposition that the right to hold specific private employment and to follow a chosen profession free from unreasonable governmental interference comes with the liberty and property concepts of the Fifth Amendment. In its granted demurer, defendants the Carlton specifically spoke not of the candidacy of the pro se plaintiff Webb, but of his failed political career. Scott McCaffrey, digital editor for the Arlington Sun-Gazette, has chronicled the political odyssey of the more weird than competitive wannabe candidate. Noting in his debut in Northern Virginia politics, Webb, 48, ran several times for office in the late 1980s and early 1990s in New Jersey. In his last bid in 1991, he garnered the Republican nomination for the 31st District in the New Jersey Assembly race, but fell short in the general election in what, like Virginia's 8th Congressional District, is a Democratic stronghold. Scott McCaffrey, Arlington GOP, to get a prospective buyer challenge inside Nova, January 4th, 2016. Even during Webb's school board race, the same local news source reiterated the de rigueur recitation of less than heroic deeds. This is not the first time Webb, who unsuccessfully sought the Republican nomination for U.S. House of Representatives last year, has found himself tripped up by paperwork requirements. Earlier this year, he sparred with county election officials over requirements for gaining access to the ballot in the school board race. Ultimately, he qualified. Scott McCaffrey, Arlington School Board candidate, Next Forum Civic Federation debate. Inside Nova, September 4th, 2017. Under the wholly inapplicable rule, Arlington County asserts that the pro se plaintiff, expressly requesting merely declaratory relief and the nominal sum of just $1, must sufficiently plead damage to the plaintiff. Commercial Business Systems 253, VA, 1997, citing Glass v. Glass, shocking the conscience and bringing to recall the famous soliloquy of a young prince in William Shakespeare's Hamlet, making mad the guilty and appalling the free. Moreover, it shocks the conscience, even under the afflictions endured, resultant damage to the party whose relationship or expectancy has been disrupted in this matter by the pro se plaintiff are not worth the nominal sum of just $1 and declaratory relief, especially after complacency in actions such as denying emergency shelter during hypothermia season, as well as permitting over 109 harassment emails transmitted in contravention to 47 USC 227C, which included in the 142 online reports submitted to law enforcement allegations that the anonymous troll was in fact attempting to incite suicide in a person with a well-known serious mental health diagnosis of bipolar disorder, amounting potentially to conspiracy to commit a felony in violation of VA Code 18.222 and or accessory to murder, a violation of VA Code 18.2-32, chargeable to accessories under VA Code 18.2-19, shocking the conscience. We may not like our political adversaries, but there are laws that dictate that we cannot kill them. Finally, Arlington County cites Mann v. County Board of Arlington County, 199 VA 169, 1957, as its primary authority to endorse the proposition that it enjoys sovereign immunity in the case at bar, and it is a precedent in which even that court acknowledged uncertainty created by contributing precedential authority, as well as its consideration as to whether at that point in time the municipality had taken on characteristics of a city and exercised many powers and performed services rendered by municipal corporations found insufficient alone to disturb stare decisis. Arlington County secondarily cites to Ligon v. County of Goochland, 279 VA 312, 2010, which held the Commonwealth is immune from tort liability for the acts or omissions of its agents and employees unless an express statutory or constitutional provision waives that immunity. Thirdly, allegedly establishing the proposition that sovereign immunity in the Commonwealth is impervious to challenge whether an act is governmental or proprietary. It cites an authority alleged to be decided in a Virginia Circuit Court in 1997 in Page County with a litigant plaintiff named Brubaker, but it may be an unpublished decision nowhere available in the open source or on Westlaw because all plausible searches yield no results. Arlington County fourthly relies upon authority from Siebel v. County of Albemarle, 283 VA 717, 2012, which brought a challenge against a county under VA Code Section 15.2 1809, which expressly provided that every such city or town shall, however, be liable in the damages for the gross negligence of any of its officers or agents in the maintenance or operation of any such park, recreational facility, or playground, and being determined to be a municipality not contemplated by that enactment, sovereign immunity was sustained. Arlington County fifthly relies upon Campbell v. Board of Supervisors of Charlotte County, 553 F. Sup. 644, 1982, which held it appears to be settled law in Virginia that a county and its subdivisions enjoy non-waiverable complete tort immunity for its intentional torts. But as to other named defendants, specifically regarding a claim of tortious interference with employment or conspiracy to breach a contract, that court granted a motion for a more definitive statement and reserved ruling on the motion to dismiss. However, as in this case, the wall of solid precedent appears to be a subterfuge to present the appearance of a solid case, which anyone who completed the first year of law school could, with great facility, maneuver around. With the same words with which such a facade in an argument present shocks the conscience, simply shocks the conscience. Wherefore, for the above stated reasons established in law and jurisprudence, in observance of stare decisis and a rule of law, the demurer and plea and bar of Arlington County should be denied, and the pro se plaintiff's demand for temporary injunctive relief should be granted immediately. Happy New Year, and next year in Jerusalem.
Jesus, keep me near the cross. There is a precious fountain, free to all, a healing stream flows from Calvary's mountain. In the cross, be my glory ever, till my raptured soul shall find rest beyond the river. Near the cross, a trembling soul, love and
Saltus Futuri is the motto of Washington and Lee University, not unmindful of the future. My name is Major Mike Webb, and I am running for U.S. Congress. Next year, in Jerusalem, in liberty, with honor and excellence, the South shall rise again. Honest.
Till my raptured soul shall find rest beyond the river.
This advertisement was authorized by Mike Webb.